Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. In a case pertaining to grant of default bail to a person accused under the Unlawful Activities Prevention Act 1967 UAPA, the Supreme Court yesterday allowed an appeal filed by the Delhi police observing that the High Court fell in error in granting default bail and should not have taken the matter so lightly. A division bench of justices observed that the conditions reasons given under Section 43D 2B of UAPA, which grants discretionary power to a court to extend time for investigation up to 180 days on application by public prosecutor, stood satisfied in the case. As such, reliance of the High Court on a judgment under Terrorist and Disruptive Activities Prevention Act TADA to grant default bail to the respondent as opposed to the specific provision and judgments under UAPA was misplaced. The factual matrix of the case was such that an FIR was registered against the respondent Lovepreet, accused of being a Khalistani sympathizer under sections 13, 18, 20 of the UAPA, sections 201, 120B of IPC, and sections 25, 54, 59 of the Arms Act. Upon arrest, he was sent to judicial custody. Before expiry of the 90-day period since arrest, the investigation officer preferred an application for extension of time for investigation. The same was allowed. Since the investigation could not be completed despite the extension, the public prosecutor moved another application for extension of time as per Section 43D2B of UAPA. The said application was allowed by the trial court and the time was extended. Subsequently, the investigation was completed and a police report filed before expiry of the extended period. However, before filing of the same and before expiry of the extended period of investigation, the respondent applied for default bail. The same was rejected by the trial court. The matter went to the High Court, where he was granted default bail. Against the High Court order, Delhi police came before the Supreme Court. At the outset, the Supreme Court bench noted that in the operative portion of its order extending the time for investigation, the trial court had observed that the extension had been sought on the ground of obtaining mandatory sanction, which was pending before GNCTD. It was held that the High Court incorrectly came to a finding that sanction had been received prior to the date of making of an extension application, and that for that reason the application had no valid basis.